We are live. Okay, we are live. This is finished finding. This is April 17th. And we are going to continue our testimony on S-135. And that's relating to credit card fees and requiring acceptance of cash. We took a fair amount of testimony on requiring that credit card companies allow the tax, any applicable tax and chips be removed from the fee structure of the credit card company. We were told there was a lawsuit, and know that if we go through with this, it's fairly likely we will get involved. And so that would ask the Attorney General's office what their thoughts were. And Meredith, I'm going to massacre your last name. So
Meredith Chaudhry.
Chaudhry. Yeah, it is French.
It is French. I married a Vermonter.
That's
very French.
Okay, well, we will let you talk to.
Thank you, Madam Chairwoman and members. Thank you for asking me to join you this afternoon. I appreciate your time. As I said, my name is Meredith Chaudhry. I am an assistant attorney general, and for almost the past 10 years, I have worked in the consumer protection unit in our office. It's my understanding that we're here to talk about S-135, the proposed law regarding interchange fees and prohibitions on taking cash. As you all are, it sounds like you've had a lot of testimony. I had an opportunity to speak to your alleged counsel that this is a novel area, as you know, and several states are looking at doing something similar. It's my understanding based on my brief research that Illinois is the farthest along in a litigation that's challenging the validity of this law. So I think it's important that we look at the procedural posture of that case. The Illinois matter, the judge granted 2 preliminary orders. The December 2024 order, Judge Kendall granted a preliminary injunction as to national banks, federal savings associations, saying that the Illinois law was preempted by the National Banking Act and OLA, the Homeowners Loan Act. But it denied the preemption or the preliminary injunction, saying that the NBA did not preempt as to non-national banks and savings associations and credit cards and debit card transactions, the card networks as they were calling it, including Visa and MasterCard. The debit cards were carved out due to because of a Durbin Amendment, so that's a little bit. And then in February 2025, recently, Judge Kendall came and said, deny the preliminary injunction as to federal credit unions because of certain carve out in the Federal Credit Union Act, but granted it as to out-of-state banks. So national federally based banks are preempted. There's a preliminary injunction telling the Illinois Attorney General that they can't enforce this law based on preemption. So it's important that we keep in mind that this is not the final word on this case, that the lawsuit is in preliminary stages, and we don't know the final outcome. As you know, any preliminary injunction issued by the United States District Court in the Northern District of Illinois is not a final ruling on the merits, nor is the court's opinion binding on a Vermont State Court or federal courts in the Second Circuit. However, it does provide some guidance as to how a court might rule if confronted with a federal preemption challenge, as at least as applied to the national banks and the federal savings associations. So we're kind of at a wait and see with that, see where that litigation lands. So I know that one of the questions that was posed was, would Vermont get sued if we pass this? I mean, I don't know. I don't have a crystal ball, but it is a possibility given what happened in the Illinois case. So as this bill progresses, I think it's really important that we think about potential legal exposure that appears to be in 2 areas. One is preemption that we just talked about. For the non-lawyers in the room, federal preemption is that when a federal law preempts a contrary state law. And the source of federal preemption is found in the Supremacy Clause, Article 6 of the US Constitution. I'll do more on that. But another issue that was raised in the briefing was that there is a potential for what's called a dormant commerce clause issue. And the dormant commerce clause is doctrine inferred from the commerce clause in Article 1, Section 8 of the US Constitution. And the dormant commerce clause is basically, it prohibits economic protectionism. That is the regulatory measures designed to benefit in-state economic interests by burdening out-of-state competitors. So the judge did not rule on any of that, but it was briefed. So it was something that I flagged as a potential area we should be aware of.
Wait, are you finished? Because I have a question.
No, I love this stuff. I can go into a deep dive on any of these if you want.
really
Most people don't.
No, I think it's cool. So just
We'll go.
make sure
Okay.
talk about split infinitives. No, just to make sure I understand in the Illinois case, the judge was saying that the federally regulated banks and financial institutions could not be covered because they're federally regulated, and it would just be the
So that's not what they said.
okay.
So it's at the preliminary injunction stage, which means that the party that brought the motion for the preliminary injunction showed there's a likelihood of success that they would be preempted. So it's not like a final rule, it's just a showing, and they have to prove that there would be an injury if they let this law proceed as the lawsuit. So they moved the court and said, hey, let's put the brakes on, because I think, and the court found that as to those, there was a likelihood that they would be preempted by the National Banking Act.
Okay, so there's a likelihood of that.
The standard is a little different. So we really don't, I mean, there's no final
Right.
word.
And then the Commerce Clause comes in, because if the federal stuff is taken out, it would just be in-state banks. And then
There's an
we'd be
argument
treating
that,
them
yeah.
differently than out-of-state
Anytime
banks.
that there's that there, so the in-state banks might say, hey, you're putting us,
So essentially, the first part of it almost triggers the second part of it in some ways.
maybe potentially, it was just the issue that they brought up. So I just thought it was something we should talk about.
Yeah.
So, I mean, the dormant commerce clause is triggered in two ways: by clearly discriminating against out of state versus in state, or incidentally. You know, if you do something and you're not clearly intending to make them different, but it's when you apply it, it happens,
Mhm.
that would trigger it as well.
Mhm.
So,
Okay, so at this point, I guess everything is unsettled. There is a preliminary injunction against two national banks. If Vermont did something, is it likely that we would end up in a similar law? I mean, I guess this committee is probably weighing, we'd like to help out our merchants.
sure,
you
yeah,
know,
it's,
but if all we're going to do is get the state embroiled in a lawsuit, is that the wisest thing, or would it be best to let Illinois carry that financial? And I'm assuming you would be the people that
yes.
would be defending us. And so that, you know, we were kind of looking for your advice as to this point in the game. What would be our wisest choice?
I mean, I think that obviously that's up to this committee, but I mean, Illinois, my counterparts in Illinois are really good lawyers, and it would be interesting. It's going to be interesting to see where this finally lands. I know that there are a number of other states looking at this issue right now, and I think Vermont's a little ahead of them. So I don't quite know. I can't really. I know Colorado and Maryland and some of the other states are looking into that, and I don't know where they are as far as their reasoning, but I know everybody's eyes on Illinois right now.
Okay. This is the first year of the biennium, so that bill is alive. And my instinct is to at least wait till a year from now or a year before crossover from now.
Well, and I pulled up the docket on Pacer and I didn't see any new filings, but I think they're supposed to have a meeting of all the parties and come up with a plan of how it's gonna go forward. So, I mean, I'm happy to pass that to your legislative council so that he knows that kind of a timing wise, if it's, but as you know, with litigation, it can go.
Yeah.
Just go all sorts of different directions.
But
So I'm sorry, I don't have a definitive answer. Would we get sued? Maybe. I don't know.
I can't see us being able to go forward with anything until that lawsuit is settled.
And I think that other states, just from my brief research, are taking a similar position.
Okay. Committee, any questions? Thank you.
I was ready for other questions. Thank you for having me.
It's easy. Thank you
I appreciate it.
for coming over
Oh, no.
and for waiting.
Take care. Thank you.
Okay, committee. What are your thoughts on this? Rick is here, new counsel. So on other interested parties. I've stated my instinct. Does anybody want to move this forward at this point? I'm not seeing
I would-
any.
In theory, like to, because I'd like to do something, especially to help our restaurants.
Right,
So, but I'm not, not sure that this, if we just get sued, this is gonna help our restaurants, so. It would be nice to find something else.
we could work on state workers and making them have to come back to work. That would help my restaurant.
No construction in downtown during busy restaurant hour.
You mean the fact that our main street is not accessible?
Yeah.
But I should, my weather's how long it takes me to get across State Street in the morning. It used to take me 10 minutes to find a break in traffic. It doesn't take me 2 anymore. I mean, that's my measure as to the loss of employees in downtown. And it's not because the state's gone out of business, it's because everybody's working from home. Which is good, but for people, but bad for downtown businesses.
I want to echo what my colleague said and what you're saying as well, Senator, which is that I'd like to protect our small businesses who are going to be, for lack of a better word, pummeled by the Canadian tariffs, among other tariffs. And anything we can do to shore up their viability and strength would be welcome. I also understand a cautious review on the table.
I mean, yeah, this. It's not gonna move. I would recommend doing constructive things, and the numbers I was hearing the other day of the impact of Canadian tourism in the state is frightening. And
Not to mention they're just a huge trading partner for us.
And if this is just visitors, yeah,
Right.
my
I know,
cost,
both of those things.
and, yeah, it is. Towns are working at making their own connections, but in the stadiums, but it's still hard. Okay, well, I'm not gonna put that on for a vote unless I get told you would like it. We are not booked until 30. Which is interesting. We can move it up because this is a vote on the Universal Commercial Code, which we have been through. We had a proposed amendment. And I think legal counsel, our counsel, and I'm looking at Rick to make sure I got it right, has counseled us that we might want to wait a year or so until, because only a few states have enacted that brand new amendment. It doesn't look like anything horrible is going to happen if we don't enact it. And once again, let someone else take the risk. Anybody in the room want to comment on the UCC or the amendment or possible amendment, which would have put into law regulations saying that if you have a trust account, such as a realtor's trust account, a brokerage account, that your creditors can't access the money in that account because it's not your money, it's somebody else's. That seems to be the understanding. Nobody's done it. Everybody assumes that's the law, but it doesn't seem to be written down anywhere, Rick. It isn't in our statutes. It's
So I'm gonna come up with.
yeah, come on up.
Much to say about it, but I can answer questions. Rick Sable, Office of Legislative Counsel. So in general, that Special Deposits Act, the amendment that you heard about last week, or you can't remember when it was, that's intended to alleviate confusion that occasionally happens where there's a pot of money that a bank's holding on behalf of a depositor. And that depositor, let's say they go into bankruptcy, and now that money is eligible to be part of the bankruptcy funds. So if that money is being held in escrow or in some kind of holding for another person, for a beneficiary, that money may not be protected from the bankruptcy. It probably is not. So the Special Deposits Act allows these parties and the bank to enter into an agreement that that money is protected and it's only payable upon an event happening. The return of the funds, the landlord-tenant agreement being over with, the deposit being returned. There's some kind of event that happens for that money to be released. But before then, it's no one's money. It's like it's being held just as a special deposit. That's why it's called that.
And this, I missed the testimony on this. I'm sorry, Madam Chair, but the proposed amendment would address that situation and say that creditors couldn't take that special money.
So it's from, remember Carl Lisman, he gave the UCC.
Yeah.
So this is a model language from the Uniform Law Commission. And this is one of their newer proposals. And Carl walked through it, and I did my best research about it. I talked to Maria, our banking counsel, about it, and your ledge counsel. Our belief is that we don't quite understand yet what else could happen with our statutes, with our Title VIII banking laws. Are they going to interact seamlessly, or is there going to be any conflicts? I advise more testimony from bankers, from the bench parties.
I guess I would say that we should stick with the trend that you just started, Madam Chair, of being a little bit more conservative and wait and see approach, and just wait to introduce this and move forward with
And this is not part of UCC.
Right.
This is the board also does model laws, like the NAIC for insurance. And then states adopt the model laws.
Just in general, I'm skeptical of model laws, especially those that haven't been fully vetted by our own legislative council.
And Maria was gone she's gone
Right.
this week.
No, she's back now.
She is back,
Yeah, and you can invite her.
but we don't have to do it. We can put in a bill to do it this year or next year, and give everybody time to work it out. The banks are a little skeptical about what it means to them and what it would require changing. So,
I was saying, I fully agree with Senator Hardy, and just want to know what problem we're solving. I get the concern there, but if there's no examples of this being an issue in Vermont and untested, I find you're more fast.
So what we could use now is a motion to approve 8206 as presented, because that is the universal commercial code and it's up or down. And then somewhere, I'm pretty sure Carl List want to send me a section by section. Did that come in, Charlotte?
I have not seen that.
I'll remind him.
Yes, I need a section by section. And okay,
I'll move H206 as received from the House.
okay, Senator Chittenden has moved that we approve H 206, an act relating to the Uniform Commercial Code as it came to us from the House without amendment. Any further discussion? If not, all those in favor say aye. Aye. Opposed say no. Oh, I have to call the roll.
Yeah,
Okay, Mark would call the roll.
Senator Chittenden.
Yes.
Senator Beck.
Yes.
Senator Hewley.
Yes.
Senator Brock.
Yes.
Senator Hardy.
Yes.
Senator Meadows, yes. Senator Cummings,
Yes,
7.
I will be the reporter. Unless somebody else wants to talk. Happy doing, I've always, you've got no one to do. Okay, so we are now way ahead of schedule. Can you drop me? I know, yeah.
While we're still on, I just mentioned the data amendment that they're gonna hear about. Really sure.
I
You mind if I just mention the data amendment that we're gonna hear about?
Peter.
The data.
Oh, no, fine.
No.
Yes. Oh, wait, did we put that on today?
I have not heard back to you for Parks and Recs.
All right, we're trying. I have another question for you, Fred. We're trying, I'm trying. I've asked the administration to come in and give their response to H 454. We understand there are things the administration doesn't like. We asked them to come in today or tomorrow. We have not heard back. They said they'll do an AOE federal update, which is pretty much useless for us. So we'll continue to try and see if they'll come in and tell us what their concerns are. Because it's pretty hard for us to know what we need compromise on if we don't know what it is. And at this point, a lot of the original governor's proposal is pretty general and short. My intention next week is to go through that bill in chunks, to quote my joint fiscal person. And I'm trying to do the foundation formula. To do that and to really get how Ways and Means came to the decision they do, we need Tammy Colby. We have been trying since January to get Tammy Colby. And have got her last Friday. Once was our cancellation because we were on the floor until 5 o'clock. She is available, she is gone all next week, but she is available at 3:30 tomorrow. Since it is a holiday weekend, I was going to try and get you out of here by then. Charlotte just informed me that she is testifying in Senate Ed on the foundation formula and weights. She went over the weights pretty much with us and just a very general talking about foundation, but we could ask if we could zoom into that, if that would work for you. We can get today
I think at 4:30.
at 4:40.
4:40.
So if that's okay, it's probably the best we're gonna get for a while. Julia can go over the numbers, but the actual theory would be best coming from Tammy. I have asked the administration if they will come in with their numbers, and I assume it's APA who came up with the numbers, but to help us understand both sets of numbers in depth, so we know.
I mean, we had a presentation with APA and they like
Yeah.
showed us what was in their formula.
Yeah, but I think now that we've got the actual thing in front of us, we need to be able to sit down side by side, because we're gonna be doing a lot more digging than we were 3 months ago.
The side by side would be cool.
So I'm trying. I haven't gotten them yet. My intention is to go on the next day and look at the above base spending. And I think we're gonna end up doing 2 days with that. We have the proposal in the bill. We have Senator Chittenden's proposal. We have the governor's proposal. So I'm gonna have Kirby go through all of those. And I've asked the tax department to come over and talk about the governor's proposal. Senator Chittenden will talk about his proposal. And then on Thursday, we're going to invite whoever would like to come to us. We've got Josh Diamond, who's done a lot of work on Brigham, and we've got a couple of advocates in the community we're trying to reach, and we're going to have them respond to the proposals. Also, would ask the school boards to see if they can get us representatives from maybe a large district or a property wealthy district, and then 1, 2, however we've got time for smaller, less property wealthy districts, and give them a chance to respond to different proposals. There is the discussion we should have as a committee, and I don't know who could help us with it, about do we want to do above base spending at all? I know there was some reservation from Brent, the chair of Ways and Means, as to the minute you get there, you are introducing some shade of imbalance and equity. So we need to have that discussion. And yeah, I think the decision is we'll see about 4/4.
Okay, do we want to go over to their room or Zoom it?
Let's do
Okay.
Oh, can we go in person?
it. Can you go in person?
If, I mean, if there's
Have
room,
you
I'd
been
like
in
to-
their room?
I'll go sit in there.
I mean,
If there's room.
it would be easier to have them come here, and they chose to Zoom on the first 2 days of this week.
So that's at 4:40.
And yeah, so I think we will Zoom in.
Okay,
Uh,
I might go down in person.
okay, I mean,
Right,
if
that
you want to go down in person,
See
that's
how
fine.
through this.
But that room is very small and very crowded, and I'm assuming there will be interested parties, sitting in there too.
I've got an appointment,
Okay,
so I go ahead, but I can watch it.
okay. So this is last minute. Tammy is valuable real estate at this point. We're all trying to get her, when we can, and believe it or not, she has family commitments and job commitments and all those kinds of things. Next week is school vacation, at least some places. So we will see if we could do that. And Murphy is here ahead of. So anyway, anybody that has any other thoughts or additions that you'd like to see to that agenda, let me know. I'm trying to get everything out on the table so that when we start working through it, we know what we're being asked to compromise on, what the problems that are foreseen are, and see if we can fix things. I think the term was get it to the Senate so we could fix it. So now I'm trying to figure out what needs are based to do the Pittsburgh term.
Yeah.
They don't do
What
partisan.
needs fixed?
Been any discussions in the chairs meeting regarding what the proposed or expected timetable is for all of this? As to what gets done before we adjourn, when are we likely to adjourn if we try to do more? And then what would be held over and for how long?
It hasn't been its shares. Well, there's been some. My understanding is I'm hearing that like the 25th, 29th, the last week in May, we're going home. And that the base of this bill will be passed by then. The actual districts, and I think that's envisioned in the bill right now, will be done by a yet to be determined groups of persons. Or we'll throw it paper up in the air and see where it falls, but the actual mapping or line drawing is going to be more complex than we can realistically.
Well, I was hoping that we would go over 40 in terms of the number of study committees that have looked at this in the past 20 years.
And this,
You're gonna be on all of them, right?
yes, at this point, I think we're gonna have one. They will come back with 1, 2, 3, or 5 options. And we will vote it up or down. Or choose one. But that all is up in the air. There is a very large, detailed proposal in the House bill. That one I am leaving completely alone. I tried to do it last year, it failed. But there will be some version, which may be what the committee of conference is on. This summer, that will be the main work. We should, before we leave here, this is the timeline that goes with the House. I would love to get a timeline from the administration as to how they see what's happening when, and I'm looking to people that have more in with the administration than I do. Okay. If we're only talking 1 year, that might be doable. Talking 3 years, that might be a challenge. So it's how we should have that timeline done before we leave here, so that schools know what's going to happen. I personally think we also need to be able to tell them what resources are likely to be available to them as they attempt that organic consolidation. Are they completely on their own, or are we going to help them build the extra 2 or 3 classrooms they need on an existing school in order to merge 2 schools together? And so that the ground rules are clear and that they know where we're going.
Structured timelines, this major issue is given where we are.
Yeah.
And given the potential effect of tariffs on materials.
Yes.
I just want to say, if we're going to have a conversation in here about timeline, I think one thing that's really important, and I don't know how many people caught this comment by our legislative council attorney, but a lot of the timeline that is in the House proposal is actually driven by election law.
Yes.
And I think that if we're going to talk about timeline, we should actually have the Secretary of State come in and talk to us about election law and the timeline of how things must happen. As a chair of GovOps, we cannot be forcing elections at a time that doesn't make sense.
Right.
So
It's not baked into this
it's
already.
baked into the
Yeah.
House proposal, but if we're trying to
Change it.
move up or change that or compromise on something, you can't mess with elections.
Has homework been done on
Yeah.
what's on that piece of paper? It's really reflects.
So
Right,
we,
yeah.
and if we can get other proposals for timelines, we'll try and get them all together. Okay, Kirby is here. And we didn't do it to Kirby. Zoom did it to Kirby last time. If anybody's on rules, I'm having a problem with, if anyone wants to shut us down, all they have to do is sabotage Zoom and the Vermont legislature can't function. I'm not sure that that's a helpful rule to anymore.
Well, it's
backup
too high of a
is-
bar.
The backup is key. So there should, there's simply basic risk management says you can't rely on a single piece of software. And so everybody ought to have the ability to use Teams, and theoretically we do.
Yeah.
Use Teams occasionally. That should be the backup, but we should just make sure that we're clear on the plan to do that in the event that we have to switch over.
I think we need, yeah. I mean, yesterday I could have kept you, it sounds like Zoom came back up 5 or 10 minutes after we adjourned. But the technician couldn't give us a timeline. We could have been sitting here at 5 o'clock and we could have come in this morning and Zoom is still down. So it's difficult to know what to do when it looks like the entire system has crashed, and it's, especially if it's later in the afternoon. Your morning committee, you got a little more flexibility to sit around, but,
It would be nice to have a fallback.
yeah, and I think we need to talk to tech and the rules about what is the fallback.
And if there is no fallback available, that's the other issue. I think conceivably you could have an internet outage that lasted an indefinite period of time. Does the legislature stop because of an internet outage, or do we create some sort of an exception mechanism in which?
We stopped the floor because of a power outage.
Mhm.
And that's,
Agenda and written as testimony, that's your backup.
there you go.
Maybe the clerk starts taking notes.
You do shorthand? Shorthand.
You know, I don't think that's very.
4 days, that's how it
useful.
worked.
Mm.
Okay, yes. Is anyone in shorthand anymore? We need a court reporter in here for the stenographer. Yeah. Okay, but that, I mean, that's
What page?
an issue, and now that we're out of COVID, that we might wanna, yeah, just kind of
That's a good weekend.
consider that. Okay, so we have gotten to 4:40. Fun. All the time curve that we got today.
Okay, I'll try to make it as enjoyable as possible.
Well, you're the only attorney today, so that's gonna make us a lot more focused than yesterday.
So Kirby Keeton, Legislative Council, I have some parts of H 454 to go over with you. Returning to what you said a moment ago, I think as far as the timeline stuff goes, Beth and John have done a lot of work on that, and you could ask them, but I think the suggestion to involve the Secretary of State's also excellent idea. I'll go into a little bit of timeline stuff with my parts, but they're not as connected to the rest. 3 major things I'll go over. One is the concept of using property tax classifications once the new system is in place. And the general idea there is to enable the General Assembly to start to adjust the rates that are applied to the tax base beyond just homestead and non-homestead. And you'll see what the 2 new classifications would be under that system. Second thing I'm going to go over is it relates to reappraisals and having regionalized reappraisals rather than having each municipality responsible to do mass reappraisals, and to have that more systematic and to put some things into place to have better data collection when it comes to the grants. That's not something that's completely linked to the stuff you've heard from John and Beth. But I think the idea is that having a clean and then a more reliable grand list that doesn't have wild CLAs that affect things going forward, will help the overall system also.
I mean, yeah, the CLA is one of the other things that has kept votes from being related to your tax bill, because if your CLA is way off, then that's right.
And so the third thing I'll go over is just, there's a few housekeeping and smaller policy changes that were put in the bill at the end of it, and I'll just go over all of those. But they're relatively small and they're not linked to the rest of it, really. They were just mostly related to property valuation or property in some way, so they ended up in this bill. So with that, we can jump into property classifications. It's maybe the more dense thing that I'm gonna have to go over with you. We start off with the section of law that deals with the contents of the grand list. So we have a statute that lists out the things that must be on the grand list that are mostly used for property valuation purposes. But in this case, adding something that's it's going to be used for tax rate purposes as opposed to property valuation purposes. So it says in subdivision 3 on line 10 there, the grand list will have a brief description of each parcel of taxable real estate in the town, including a classification assigned pursuant to section 5152A, which is what we're going to get into. That's the classification section. And then there's another change here that's a technical change that is not related to all the rest. This is a request from BCGI, who do mapping for the state based on parcels. And under current law, so this is like a technical thing that's a total footnote, a side issue here. So I don't want you to think that this relates to all the rest of it. But under current law, if there's two contiguous parcels that have the same ownership, they go on the grand list together, but sometimes those parcels have way different uses. And so BCGI, and they're way better to test on this than me. So I'm giving you Cliff Notes version, that it helps their data collection if the grand list would actually have those as separate parcels. So we've changed the definition of parcel on the grand list to say, as used in the subdivision, parcel means a separate and sellable lot or piece of real estate. Parcels may be combined to represent all contiguous land in the same ownership together with all improvements that are made. So that adds some flexibility, and they believe it will allow them to collect parcel specific, or to have parcel specific data on the grand list that they can use for mapping.
I can think of examples of that in my family and region. Will they now get separate tax bills for each parcel? Will this no longer be one bill with all the parcels? Is that the effect of this?
That's a good question. That might be up to the town. I don't know enough about the town systems. It might differ from town to town. It should not affect things outside of property valuation. It should not affect, say, any property rights that are associated, with those parcels or anything like that. Yeah.
I know people who actually ask for 2 tax bills and keep them because it's a lot easier to sell them than having to subdivide your property.
And the towns have accommodated that?
Yeah.
Yeah.
Well, I don't know if they will anymore, but yeah.
So that's that change. It's on the side. But the big thing for our purposes here is the fact the grand list will have a tax classification.
What page?
Did you?
1/3.
1/3.
1/3, yeah.
Did the realtors testify on this in the house?
Yes.
Okay.
There was a lot of testimony in the House. This I've drafted, I don't know, at least 10 iterations of this. It's gone over drastic changes over time. The version we have is something that where I went back to the drawing board the night before they voted it out and redid a lot of it. Which also means I can get to it. I have a few notes, some things I'd like to maybe adjust because it didn't get a lot of review.
Our challenge is to come up with something totally new, right?
Oh, really?
No,
Go.
Whatever. I've done so many versions, you can do what you want.
Them already.
So getting into the classifications, how it works. So there's a new section of law, that says the grand list of a town shall include one or more tax classifications for each parcel of real estate. Parcel shall be classified using one of the general classes of real estate that we're gonna get into. And based on considerations set forth in this section and by guidance provided by PBR. Listers and assessors shall annually update the grand list to include a tax classification not later than June 1 of every year. June 1 is the date to put these classifications on the grand list because it's before the new fiscal year, before tax billing. But it gives enough time for homestead declaration and landlord certificate data to get to the tax department. It gives a little bit of extra time for people who get those in late. So that because as you see, these definitions are going to rely on data from landlord certificates and homestead declarations.
I think that may be one of the gates fees. We did some adjustment to the miscellaneous tax. There was a couple things, at least there was no fee for filing later than, because the tax department can now turn things around.
That's one of the technical, we actually missed one last year.
Oh, okay.
That $15 fee was in 3 different places in law. We took it out of 2 places last year and we missed one of them. That's one of the things we missed. Yeah,
We'll get complaints when somebody gets.
I mean, the department's not been imposing that late fee, but we should take it out of the law.
Well, since we're not getting miscellaneous tax this year, we're gonna have to do it.
Right, and that's also why some technical stuff's in here, because there wasn't no miscellaneous.
Yeah.
So, all right, moving on. So you see why June 1st is the date for this. It's set up prospectively where a person or the information that's being attested to in the classifications is being done for the current year. You know, sometimes for some things like property tax credits, we've looked back. There's no looking back in this. For all the classifications there, how they'll be used for the current year is how they'll be classified for the current year. And I told you there's a lot of iterations of this. Some of the iterations did kind of look back, and there's some not great feedback about that. And so this is set up to be current year, which means it has to be structured in a certain way to do that. We'll get into it.
Okay, so it's in the current year, so.
Yeah,
If I know I've got an empty residential property, but I know I'm going to start renting it in October, I will have to put it down as a resident property.
for
in
this,
June.
the classification for apartments, we'll get into it, is you have to attest that you'll be leasing it out for 6 months to a long-term renter. So yeah, if in December, when landlord certificates are filed, you think that you'll be using a property for renting it out for at least 6 months in the upcoming year, that's when you would.
And do
declare
that,
that.
and then I would declare that
Mhm.
here. Okay.
And that's also why that June 1st day gives people little time more if things
Because
change.
properties could change hands, they could be
Mhm.
estates, and the family might inherit and decide to rent.
Right, in this whole area,
Making changes and adjustments to
in
this. for a
this whole
while,
area,
but-
yeah, how people use their property is fluid
Yeah,
and it's a hard area to nail down.
it is,
And I think we know that from our experiences with a lot of things.
which I think we
law.
learned that putting any kind of a serious penalty on these results in so many hardship stories that the legislature for several years changed these dates annually until, because there was always something terrible that happened because somebody didn't know. And so, yeah, so there's no terrible fees on this.
No fees, but you know, the assumption is that there will, although this bill does not have different rates, the assumption is there will be different rates
Yeah.
eventually, and people will have incentives to have their property in one classification rather than the other. And that is something to keep in mind. And that's an intentional policy lever that's built in here. That's not finance it, right?
On the other hand, even if no one intends to change any taxes, it would probably be good for us to know the ratio of full-time residential to apartments to business so that we could track,
Mhm.
you know, is 80% of our stuff rental, you know, non-homestead residential, which generally means second homes, and, you know, be able to monitor is that going up or down? Because we've asked for that information for several years. Just because non-homestead is so diverse.
Mhm. And we currently, we don't know how many rental properties we have. We don't know that. We have the landlord certificates, which should tell us that, but we also know that a whole lot of landlords don't file them right now.
Right.
When their tax rate will depend on filing or not, there may be some more incentive, and that's something that's built in here. The assumption is that the reason why there's an apartment rate that's separate than the others is what we know about how people tend to operate in this building is that would, my expectation, although it's your decision, my expectation is that that's built in to be lower than, say, second homes. So there would be an incentive to try to be taxed as an apartment and possibly incentivize more apartments, or at least have converting vacant property into apartments.
One thing I've learned around here is that words matter, and I'm just curious why they stuck with the non-homestead apartment, because aren't these multi-unit living or multi-unit dwellings? They're homesteads. I mean, people live in apartments. So I'm just wondering why we kept that terminology for classifying apartments where people live.
It's the history is that the very first versions of this were based off of Hawaii. It's nothing like Hawaii anymore, like what you're looking at, but Hawaii has an apartment classification. And that's it basically, yeah, this is rental units. It could say non-homestead rental units, non-homestead rental, non-homestead. It could say something like that.
Because there's a specific definition of homestead. And so it has to be non-homestead, because homestead is what you live in, that's your home that you own. Non-homestead is somebody else owns it and lives in it, but it's still residential. So, I mean, I agree that apartment is a little confusing because it could also just mean a single family home, that it's a rental, it's not an apartment. So that was one thing for me that I would like, can we change that to non-homestead rental?
Yeah, it could be non-homestead rental. That's essentially what it means.
Yeah.
And they used to have 9, because not all apartments are the same. I think when we were looking in the last year, and we had the proposal was to raise the rates on non-homestead in order to raise the money to be able to fund the the tax income sensitivity section because of all the complexity with that. And we found out that all your subsidized apartments that we have been working very hard to build can't raise their rent. So they have no way to raise the money to pay a large increase in their property taxes, whereas a regular landlord can pass that on to the tenants. The public housing can't. And this one puts them all in one. And at present time, everybody's being treated the same, but if there's any toy with that, that's something to keep in mind. That
I'm just picturing right now the requirement and request for funds to build a variable property use tax tracking system, one.
oh, yeah,
Then there will be a request for additional staff because of the burden of keeping track of all of this stuff. And at the end of the day, I'm not sure that we actually made a profit if that was part of the intent of this. But we made, the legislation more inclusive, so we'll need something in excess of the 34 volumes plus appendices we have now to keep track of it. And will anything be any better aside from more bureaucracy?
We can have that discussion. How are we making it better?
So, getting into the definitions for each of the 4 classifications. The first is homestead, which you're all familiar with, it's current law. So a homestead's a parcel or portion of a parcel declared as a homestead on or before October 15. October 15 is the absolute final date in current law that those can be filed. So that stays the same as current law. And that is something that is filed in the current year. Person declares their homestead and they receive that tax treatment, right? The second one is, and these are just alphabetical. Non-homestead apartment means a parcel or portion of a parcel with 1 or more dwelling units. That's one part of it. For which a landlord certificate was filed in the previous year, and the landlord attested that the unit will be leased to a long-term tenant for a minimum of 6 months in the current year. One thing that was brought up in this conversation earlier that's not specifically called out that I need to think about is because of this definition, there can be people who are just now opening up a property for rental. And they would not have had to have filed a landlord certificate in the previous year, but they might want to attest to how they're going to do it in the current year. So that's a thing that I should probably account for in the language here. You understand that your apartment, if you've attested, and I'd like to clean this up in general, but I think the idea is that a person correctly, you can't just claim you're going to do it to get this tax rate. You have to correctly claim to attest that you'll rent it out for 6 months in the year. And if that turns out to be true, that will be your classification. And for the most part, it's going to be up to the department whether or not they want to look into chasing those down. As I mentioned before, I just want to give you the full picture as much as possible. We don't have 100% compliance with landlord certificates right now. So between now and this taking effect in 2029, really the data collection for it will start in 2028, which is something we'll get into. Between now and then, so there needs to be a lot better compliance outreach to get people filing landlord certificates to make this thing work.
Do you know what percent do?
I don't know.
I was gonna ask the question too.
I don't know if an exact percent is known, because we don't know how many there are.
Yeah, valid point.
But we know how many, the department has something to get, and they know that there's got to be more than that. And then occasionally you'll have someone file up for a rent rebate. One reason why we don't is because the whole reason for a landlord certificate is the renter credit. Sorry, I said a rebate. And not all tenants, of course, qualify for a renter credit. And if you're a landlord and you know that your tenant doesn't qualify or they're not going to be filing for it, why bother? It's part of it. There's also a lot of landlords out there who just don't know that they have to do it. So the department has testified that, of course, they receive renter credit claims with no associated landlord certificate, and they have to chase that down and make the landlord fine. So that's one reason we know we're not getting it.
Yeah. There's still a fair number of people that are renting out a space over the garage.
Mm-hmm.
This is still Vermont. 911 was difficult to put in. I can guarantee that's why it's a separate organization, because people did not want the government to know where they live.
Mm-hmm.
And I can guarantee you, some of those same people are not registering with the government that they're renting out a room or an apartment, because it is none of our business. And that's gonna stay.
And it may turn out, their tenants though might be entitled to a rent refresher, right? And they're making a decision for their tenant to not receive that, potentially. And so there's some penalty in the law for not applying. And that might be something that has to be revisited when we start to rely more and more on that certificates. We
might not want the government to know where they're living.
As a side note, we rely on the landlord certificate for the new transfer tax rate that was passed last year. We discussed that a lot in this committee. You had Jake Feldman from the tax department would come in, and I was happy to be in this room and saw his presentation where he put some holes in the way that that works, because there's certain type, you remember his PowerPoint where he has the pictures of the different residences?
Yeah,
And he said, which ones do you think that the transfer tax rate applies to? And it was the one that was being renovated and not the big house with the yurt. You
Yeah.
remember all that? So just as a side note, we could revisit that as your attorney and can work on that with you. If you were compelled by Jake's testimony, we can clean that up.
and I
Um,
thought
But-
somebody from economic development told me that there were problems. That the tax department, Keisha in the hall, said that there were issues and they couldn't remember last year, there were like 4 additions to the property transfer tax, but there were 3 different versions. And part of it was trying to get money back to the 911, no, not 911, Act 250 board, because in doing away, in limiting the number of applications of things that had to get applications, we were doing away with their application fee revenue. And they were looking at a shortfall, and the House had a version. Senator McDonald put out a version last year. And our economic development, there were at least 3 on the table. As to some of them that are graduated depending on the price of the house. I think the one that went through and they're having trouble with was from economic development, and you had to declare if it was being used as a second home. If it were non-homestead residential now. So we'll have to hear from the tax department as to what has happened with that. I don't know if that tax has been.
So I brought that up to say that that new transfer tax rate also, part of that the definition that apply there have to do with the landlord certificate.
Yeah.
So, you know, as more and more things are being based on the landlord certificate.
Non-homestead
compliance.
residential and doesn't have a landlord certificate is I think how that went. It's if being rented. Then.
Yeah, we're about to
Pay the enhanced,
So we're about to get to that one. Let's do it.
yeah,
So non-homestead residential for the tax classifications means a parcel or portion of a parcel with 1 or more dwelling units. Habitable on a year-round basis. Which
no deer camps.
Jake has said that that's hard for the department to determine, but I would say that that's the sort of regulatory thing the department.
Well, I think
Has
last
to
year
do.
we heard that a lot of the towns frequently, if not almost always, do some of these classifications. The lister knows locally. Sometimes,
Mhm.
if this is a habitable
Sure.
year round, there's some judgment calls in there.
And there might need to be some regulations to better define that.
Yeah.
But anyway, this is just to make sure that the deer camps don't get taxed like second home.
Right.
So,
We know what's sacred is.
And then, going on with the definition for which a homestead was not declared, so no homestead declaration for this parcel or portion. And the landlord certificate was not filed with an attestation of being leased for 6 months. So not a homestead, not being leased for 6 months according to the owner. Habitable year round and does have a dwelling unit. This is a tricky one from administration though. One tricky thing is that, how it assumes that the department's going to know what properties have dwelling units. And we do have grand list data. There's like, not to be confused with classification, but there's like categorization on the grand list that the listers do. That has to different types of residential and commercial and other things listed according to what, you know, the work the listers doing. And that's one of the best sources we have to work with, but it's not going to be perfect. So there's work to be done here. to identify those dwellings, because when the department doesn't receive a land certificate, they don't receive a homestead declaration. The question then becomes, well, is there a dwelling if there or not? And if there is, it should be non-homestead residential. If there's not, then it would be the number 3 on the page there, which is non-homestead, non-residential, which is what you think of as non-homestead right now. It's the catch-all.
When we first looked at this, and it had to be occupied 6 months of the year. The listeners and the town clerks are in saying, who determines that? Are we supposed to go out and see if the lights are on every night, 6 months?
For homesteads or something, yeah.
Yeah, I mean, it is like most taxing systems, an honor system with the, the threat of an audit, keeping you honest. I'm quite sure there are some residences out in the hills of this state that aren't on anybody's list. It's pretty rural out for some of those roads, and people driving by don't know. If the town clerk doesn't have to go up that road, nobody knows there is that. Yeah.
So,
Been there
yeah,
a long time.
so, that will continue that challenge. So some of the challenges associated with this are, there's some more provisions here to kind of cover different things. So in sub D, line 10 here, we have to deal with mixed use. And that was a problem in putting this thing together in the first place. How do you deal with mixed use? With the assumption that you're not going to have staff go out and do what you're saying, check on how every single property is used. So what this does is it takes inspiration from what we currently do with homesteads. When you have a business use and you declare your homestead, it asks what % of floor space are you using for your business? And under current law, which this retains current law, if it's 25% or less of your floor space that you're using for a business purpose in your homestead, then your entire parcel just gets treated as a homestead. But if you exceed that 25%, then that portion that's used for something else gets taxed as non-residential. This is under current law or non-homestead.
So we're looking at cottage food production. I had a friend who made chocolate chip cookies in her kitchen that got sold in local stores. If her kitchen was less than 25% of her square footage in her property, then she isn't that. But if it's a really big kitchen and it's 40%, and when you've got open floor space, there'll be some challenging there. But if it's 40%, then that is charged at the business rate, which is something we've gone through with B&Bs for years. That sometimes only their bedroom ended up being classified as non-business because the guests, when they were there, had access to almost every room in the house.
And so one thing the current law, where you're getting one thing the current law when it comes to homesteads and business use doesn't fully address is when you have a space that's used as a homestead and also for business purpose, both. There's not a time under current law. So there's some ambiguity there. And since homesteads are mostly just self-declared, it doesn't really come up legally a lot, but it is an ambiguity that we have. We try to address it here. So that's the sub 2 you see below. Sub 1 just says our treatment of homesteads and how we've been doing it, we're going to keep doing it that way. Sub 2 says if a portion of floor space is used for more than one purpose, the use in which the floor space is most often used shall be considered the primary use, and the floor space shall be dedicated to that use for purpose of tax classification. So it answers the question that you just posed, which is, let's say you have guests or, you know, customers stay at a portion or have access to a portion. If they have that access for a majority of the time, then you would put that down as a business purpose, business use, and we tax as one of these non-homestead categories. If that use is actually very limited, it's only a couple hours a day, say, under this language, that could still be a homestead. Like that amount of floor space is still homestead. So the time component is addressed. Moving on. Sub E says the commissioner shall amend existing forms and publish new forms as needed to gather the necessary attestations and declarations required under this section. The reason why new forms are called out is some of the issues we've gone over about the second homes. Just to revisit, because I think I didn't spend a lot of time on it, but the non-homestead residential would be like second homes, it would be like short-term rentals, and it would also be, as Jake's pointed out, when it came to transfer tax, properties that are just vacant, residential properties, dwelling units that are vacant for other reasons, such as renovation, or someone just keeping it vacant, even though they don't consider it a second home. So really it's just vacant residential properties is one way to think of that. Or those used for short-term rentals. Okay, so moving on, publish new forms. There's work for the department to do to figure out how to administer some of the tricky parts of this. Sub F, nothing in this section shall be construed to alter the tax treatment enrollment when it comes to current use. So that's just addressed expressly in the questions. And then sub G is about appeals, and if a person does not agree with the way that their property is classified, they would go through the normal property valuation appeals process. So that would be grievances, then the Florida Civil Authority, then the Department of Taxes, and court. So that's it for the section on the classifications. We have some other stuff, related stuff. I can stop there for questions on that.
So Kirby, it seems to me like camp would fit into non-homestead, non-residential. You know, camp not habitable on a year-round basis, not being rented out as a long-term rental. They would be non-homestead, non-residential,
Yes.
right?
Yes.
Wow, puts them right in line of fire.
Why is that the line of fire?
Well, I think that's the intent here, right? Was to eventually get a higher tax rate for those people.
I think it's the non-homestead residential.
Non-homestead residential, those are the second homes.
Forest, right?
Or
Like site.
the non-homestead, non-residential are businesses and
Deer camps.
in deer camps.
Where do you think they would fit?
They would fit under number 3, deer camps. Is that what you're asking about, or lake cottages that aren't, they would be non-homestead, non-residential,
Right, and non-homestead residential,
are second homes.
non-homestead apartment are being rented long term.
Yeah, the apartments are rented long-term, the non-homestead residential are second
Long-term.
homes.
Deer camps would be taxed like commercial, industrial, vacant land. Those would all be taxed with the same rate.
If the landlord is testing the deal, it would be leased to a long-term tenant for a minimum of 6 months.
And that would put
It's a
you
long-term rental.
that would put you in an apartment in that case. And then, you know, if you were to speculate, I would think apartment's going to be one of the lower rate for the non-homestead rates.
In order to
We're talking,
incentivize rental property, incentivize apartments.
And to avoid having renters be hit by property taxes.
Yeah,
that's not all seasonal buildings are equal. When we're talking deer camps, that some of them I've seen have outhouses and you have to truck in your water. We also have some very nice lakefront property.
Oh, I see, okay.
but if those, if that lakefront property is year-round property, it would fit into category 4.
Rented it for the 6 warmer months, or you were you're gonna have some fuzzy gray areas.
So I did make this chart, which is on the committee page. If you feel like you understand the classifications, then we can move on. If you feel like you want more on how to figure out what's what, I can go through the chart.
Maybe what would you like to do? You're okay?
Yep.
All right.
I see you have, can I have that?
Yes.
No, I didn't have, like,
I get you.
you understand what it is you don't like.
That's fair.
Could I do that?
Yeah. Yeah.
So regarding the four classifications, homestead, non-homestead apartment, non-homestead, non-residential, and then non-homestead residential. Was there any discussion in the House regarding 2 and 3, which would be the non-homestead apartments and the non-homestead non-residentials, as possibly combining them into one, with the thought being that apartments are generating revenue for the landlords, and if anything, they are in that way either an investment or a business property, and that they should be lumped with the businesses that fall into the non-homestead, non-residential category 3.
The Department of Taxes brought that up. The Department of Taxes testimony, it was along the lines of, this is a lot for us and we would like less.
Combine those.
And so that would be one area where if you don't do that, and so I'm sure you'll hear from them.
I'm sure we would.
So yeah, they could talk about that. Out of the 9 that were thrown out at first, you know, not all of them had, I don't think, a lot of policy intent behind the different 9. There were a few that there is policy behind.
Right.
And the 2 that we have here are 2 in which there's like a policy reason that the House wanted. Apartments for policy reasons because of for purposes of relief for renters and so forth. And the other second homes, the short-term rentals, to disincentivize those things that haven't paid one. And that's, you know, putting words in the mouth of the House, but that's just, I think, between the lines, what this is about.
Thank you.
Yeah.
And I also will say that there's a lot of work behind this. There was a major report that the tax department did about property classification and reappraisals and everything. So it's not like this came out of left field for them. They've been working on this toward this for a long time. And this also would go into effect. We haven't gone to the effective dates, but it doesn't go into effect for a couple of years.
This would go into effect January 1st, 2029 because of the data collection aspects, but it's meant to, as far as when for tax billing purposes, it's going to be the same time as the ed reform stuff.
Just to kind of get this right. Fine.
Yeah.
And we'll need to be data collection in 2028 though, and we'll get into that in a minute. Because as you saw, you need to gather some info the year before in order to get the attestations you need for the next year. But yeah, that's the effective dates. Okay, so moving on to the next part, there's the transition. Actually, this is what I was just talking about. So for calendar year 2028, basically, there's session law here saying tax department's going to do the forms, going to do the data collection as if this is law to get the info that's needed in order for in 2029 to start doing the classifications. And that was kind of my call as a cleaner thing instead of trying to play games with effective dates or something. Thought it was just cleaner to have them do it that way. 61B this is what was added on the House floor. This was the study that was discussed before, how there's going to be a study on classifications. This is just having the Department of Taxes at the end of 2026 is the deputy report back on what they think is needed, how they think this is going as far as their prep and setting this up. It's an opportunity for the department to come in and say, this is a lot harder than we thought, or it's a lot easier than we thought. I think the interest in the floor amendment was to make sure the department has a way to chime in the meantime. Obviously, the department could do this stuff without this. The risk is taking the obvious. They can come and tell you things without this.
And I think we started looking at this, I think Rebecca Ballot was pro tem. And that was rent, and that was again, looking at the housing shortage and rental, and that's when the discussion came up of rented less than 6 months of the year. how do you determine that, you know, does your lister go out? Check if there's a car in the driveway and how often. And the tax department, we've asked for this information, and the result was major study. And I've tried to get the tax department to come in and go through that, but we haven't gotten them scheduled yet to go through what they see. And I can try and get that in next week or when we take this up, because this will be a chunk we're gonna take up. And we will have them in to talk about, you know, these are the issues they see, these are the pros and the cons. We will hear from the listers and from property valuation, and then we will hear from the advocates. And we'll see where this goes.
Kirby, a very respected news agency, covered the House debate last Friday, and the coverage indicated, and I had the impression that the classification thing was stripped with the floor amendment and replaced with a study. But I've since heard that that was actually not necessarily absolutely correct. Would you just clarify here that this, the 4 classifications is set to take effect 3 years from now, not as a study, that is going forward, and then this additional report information is just to further inform that approach that we are committing to in this language?
Yes, the classifications were not stripped. They were changed in committee and House Ways and Means drastically before they passed out. But the classifications themselves were not changed on the floor. That section that we just looked at about the tax department report back is what was added on the floor.
I think originally there were 9 classifications, and then took them down.
There were 4. One of the only ones that's consequent, I would say, would be that there was this ski resorts classification that people didn't love. The people from the ski resorts didn't love.
Yeah.
Specifically.
They are now down as commercial.
There was also at the same time, you know, there's property tax exemptions for snowmaking and ski lifts. Those were gonna be stripped out, but that's not in here, you know.
Okay. Well, we will get. When it comes to skis and ski lifts, and I guess over time, there's been a lot of negotiation, and there's revenues the state makes from many, if not all, ski areas.
I think it's only 2.
Okay,
It's actually.
but we will, I've been told before we mess with it, we should know what it is, which is usually a good idea. So right now, as this bill stands before us, I'm assuming they're either commercial or you've got condos, or so it'll depend on if the condos are owned, and it'll depend on if you're renting out rooms and portion, but that's pretty much happening now. You're either residential or commercial. So as long as you're having camps.
So a few notes before we move on to reappraisals. So we're done with the classification parts. I mentioned that if you want to work on this, I have a few technical things.
Well, I think we want to at least fix the technical things.
Right, okay. So just so that I let you know what I'm aware of.
Yeah.
With apartments, the language relating to making sure that the certificate, landlord certificate is not filed incorrectly, just to change the classification. We want to make sure it's tied enough where we're not allowing loopholes, things like that. So that's one thing that I'd like to address. So wordsmithing on page 130, line 19, to make sure that the ability to do mixed use, that is to have more than one classification prorated on a parcel, is But I think it's pretty clear about that, but there's at least one sentence that I'd like to make sure does not imply that there's no mixed use.
One thing we want tax law to be is clear to the
Yes.
average person.
And then, you know, in some places, make sure that like when we mention homestead declarations and lumber things being filed, I'd like to put in correctly filed. To again, avoid any loopholes where,
Where is that? What landline?
like one of them's to like page 130, line 19. Also, if you look at the definition for homestead, say, which is, line 13, page 131. It says declared as a homestead, I like to put correctly declared as a homestead.
Okay.
And then
You know,
in which, in on line 17, in which a landlord certificate was correctly filed.
yes.
That's, and you and Mike and Grady and I don't talk about split is there. We had.
Or not.
I'll spare you. I'll just talk to them.
I just want to make sure they're correctly filed. If you've got language suggestions, go for it.
Don't
Yeah.
even.
Don't start.
Go there.
Seems to, I'll make sure I end this sentence in a preposition one.
Yes.
Okay. Some other things to know real quick, section 78. This later on, there's some, conforming changes. In section 78, there's, a deadline that's being changed when it comes to current use. This should not be changed. And, there's also a reference to a regional property valuation board on page 142 that I need to remove. That was something that was from the previous iterations of this in the house, and it was at one point the house considered changing the appeal structure when it came to property valuation appeals, and that has now been forsaken, and we're using current law for those appeals. But there was one of this, they had imagined this regional property valuation board at one point, and I got through. So I need to. So there's some cleaning up.
You mean
Section
things got mixed
79.
in the morning when this?
Yeah,
Section 79 has no changes in it. So is that
these are things to do. There's
Right.
plenty of flaws in this version.
right? So it's 79 was in there because they were going to do an appeal thing, but now that it's not, it should just be taken out, right?
Well, section says 78, so that's the thing.
No, you said 78, but look at section 79. There's nothing changed in it. It looks like it's a,
Oh, no, it says appeals.
says appeals,
Amended to read, and then it does appeal.
but there's nothing amended.
Underline.
There's nothing underlined or crossed out.
So you get.
There's not a-
G in
there's
that
not a
date
date.
information to Jan.
Not in section 79.
Well, figure out what it is that needs to be technically changed.
Yeah,
If it's no longer in the law, then, but you may have removed it
and it may, I don't, yeah, I don't know.
that last night.
I'll double check that.
Okay.
Okay, so I'm gonna. So go to the,
Section 62.
section 62 is the regional assessment districts, yes. So we're done with classifications unless you've got more, and we're gonna move on to the next big thing. Starting in 2030. There will be regional assessment districts in this language. The reason why that date is so far out is because municipalities are still under orders and still contracting to do reappraisals right now. So we'll get into it, but there's a timeline for that, and that timeline is based off of allowing municipalities to wind down doing their own reappraisals and then switching over to a system where basically by county, the municipalities would work together to contract for reappraisals. And this is the Act 68 report that Senator Hardy mentioned a moment ago. It's that the Department of Taxes worked with consultants, the International Association of Assessing Officers, and produced a very large report, Act 68. Mostly it was about reappraisals. There was stuff in there about classifications, but it's mostly about reappraisals. And then a lot of what we're about to do is just kind of a lot of the suggestions how that would work. And one of them was about trying, when you do a reappraisal, the target was to have at least 10,000 parcels that you do at a time. And so this is based off of counties, because if we do counties, we'll hit that 10,000, except for, I'll just jump to it now.
Franklin County, Grand Isle.
Exactly. Franklin and Grand Isle are together under this because Grand Isle doesn't have enough. They don't have 10,000. And Essex and Orleans are put together because Essex is the small one.
Yes.
Right?
like
They don't have,
nine.
they don't have 10,000 parcels. So those are why those are put together. So there's a legislative intent section. I'm gonna go back to the top and start. There's a new subchapter added, under, chapter 121. There's a legislative intent section because this is to guide PBR in the going forward, because there's a lot of regulatory guideline type stuff in order to direct, to some degree, these reappraisals. So it says the intent of the General Assembly to create regional assessment districts so that properties on grand lists are regularly reappraised. 2, property data collection is consistent and standardized across the state. And 3, property valuation is conducted by trained and certified individuals and firms. Again, that is to guide PBR when they have to make decisions about how do we do these regional assessment districts. This is not saying that listers and assessors right now are not doing those things. There was some backlash. That was, because these words were from me to help guide PBR. And I certainly was not thinking that listers were doing a bad job or nothing. So just to clarify that, right?
They just can't get appraisers to do reappraisal.
There's all sorts of issues with reappraisals and being able to contract for reappraisals, including if you're too small, firms don't want to do your work. Okay, so moving on, so the establishment of the regional assessment districts, there will be 12. There will be, member municipalities that work together under these. The municipalities are driving the bus on this, the way it's written now. At one point, the version of this in the House was to have PBR driving the bus and directing these. Still doing it regionally, but being more in charge. The department has been in favor of not taking that on. They've been in favor of having municipalities work together to do it and then kind of assisting.
I'm in favor of that.
Of which one?
In favor of the towns working together. However, our track record is not great in that area. Well, so having PRV as, if you can't play nice together, then PRV will do it for you. Might be a good stick to have, because this is giving up some local control. It's giving up your local listers board. It's giving up local control of your grand list in some ways. And you know, there'll always be somebody that's yelling, why pay that much? Or we should be paying more than that town is, or so I think there needs to be an incentive to play nice with others.
So yes, we'll have to see how this contract works, but so the way it works though, at least in statute, is that they're required to work jointly to reappraise. They are allowed, they're not required to hire just one reappraisal firm though for the entire reappraisal. Language is written so that member municipalities shall contract jointly with one or more third parties to conduct reappraisals, because there was some concern in the House that maybe they need just to cover the whole county, hire one more firm, right? So that's allowed. Whether this language leaves the room for a rogue municipality who says, I'm gonna get my own, forget you guys. I mean, I don't know.
Right now, they can't get.
This doesn't absolutely prevent controversies,
Yeah.
I'll just say.
Wait a second, Kirby.
Yeah.
So. I guess, absent county government, which I really wish we had, creating this kind of thing, I think makes sense. And I guess a counterexample to that, or an example of where they have been working well together is the CUGs, actually. Those are regional, municipalities.
They are separate municipalities.
Right, so that's my question here. Is this these two paragraphs are it?
For
To
what?
create these new assessment districts?
As far as the establishment, but there's more for us to go through about some of the details.
But-
And many of the details though are going to be left to PDR. And that's the next thing we'll look at is,
Well, I guess that's the thing I'm a little concerned about is like, how do we make sure that municipalities are working together, having like a member from each on a oversight committee or something? Kind of like what CUDs are, or what, regional planning commissions are, or those kinds of things. There's not structure to this in a way
the
that creates.
structure that is there is that each municipality in that regional assessment district, in that county in most cases, will automatically be a member of that regional assessment district
Mhm.
and have a seat at the table to.
But what's the
Work on this.
table? There's no there's no definition of a table here.
We can build it.
Or financial response.
And this is where if we had county government, it would be super clear what the table is. But lacking that, we need to define what the sort of entity is that we're creating a little bit more.
So then the next part, this is not gonna
Let's
address,
finish this and
it's not
find
gonna
out
address
what
all
it
of your
says.
concerns, but it at least will
Okay,
give you an idea of what this
Yeah.
does for it.
Then we can-
So standard guidelines, procedures, rulemaking, PBR shall establish standard guidelines and procedures and may adopt rules for regional assessment districts, including one, guidelines for contracting with third party to conduct or assist with reappraisals, including standard reappraisal contract terms. Two, standards for the collection and recordation of parcel data. Three, requirements relating to information technology, what camera systems to be used, that kind of thing. And four, standardized practices for a full reappraisal, including cases in which physical inspections are necessary and how technology is to be utilized. This specifically opens the door for so that the law is not requiring a physical inspection for every mass reappraisal, that there can be satellite imagery and such used instead. Which for some remote areas and things there was testimony to support. There's some room here for having some structure where PBR insisting on some structure, but I would tend to agree that it's not one. There's not a lot of provisions here to create a lot of structure. I think that's right. And two, there's also, this is all up to PBR's discretion. So if PBR wants to completely stay out of how these are organized county by county and not try to standardize that, they could.
Okay, but what if the towns can't agree that select board meetings end up with citizens yelling,
Mhm.
we're not paying that much, we had our own lister and he knew us and
They'll still have their listers. They'll still have their
yes,
listers.
but I mean, we used to appraise our own and, this, so I think if the towns, I think we're going to need an incentive. And probably a carrot or a stick, but an incentive to say to the towns, look, you just can't dig your heels in and say, sorry, we're not paying that much. We're not, and maybe the CLA, the goal is to do away with the CLA.
I do see there is a working group.
Yes.
So,
And you also have, again, you have until 2030,
Right.
to
flesh this out more.
or to decide to do major changes like, forget it, we'll have PBR. The box off at VP or at PBR.
Yeah.
Or whatever.
We'll have the league and the listers and the clerks all come in and talk to us.
Well, I also think we should have Jill Remick come in and talk about the report,
we
because
definitely
this
should.
comes out of that report.
Yes.
And the GovOps committee did a ton of work on this a couple of years ago.
I have asked, and we will
Yeah.
ask again to get them,
And that report is published. You can find it now and look it over. It's pretty long.
came out December, right?
I just want to make sure I'm clear, Kurt. So. Well, this regional assessment district, but each municipality will still have its own listers, its own appraisers, its own appeals process.
All of that's unaffected. All of the work that the listers and assessors do that's not mass reappraisal,
Yeah,
they'll still do.
okay.
And that's property tax exemption decisions.
Yeah.
It's the general maintenance that happens year to year.
Abatement, I mean, all
In
this-
between, the grievances, that's part of the appeal process.
Okay, that needs to be more clear in here. That's a great question.
I think
That's
there-
all left untouched. This is just dealing with mass
Mass
reappraisals that under this subsection that we were just getting to. That PBR will have a schedule where there's a mass reappraisal for each district, each regional district every 6 years.
Isn't,
And that is when this stuff comes into play
Oh,
every
okay.
6 years. And then everything else, day to day, year to year,
is the same.
in between is the same as
there is a lot of confusion in this building right now at that point. I think.
Yeah, well, I was confused about it. So maybe adding language that says nothing in this section shall blah, 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 you know? Because thank you for asking that.
That's because, again, this is just like the classifications, this went through a lot of iterations. And there's probably people out there who don't know the most up-to-date version and they are truthfully saying stuff that was in here from a while ago.
Mhm.
So, yeah, so you know. This is the state is very much hands-off kind of version of this R80.
This is a clear compromise.
I mean, just remember the pushback we got last year when the state was going to evaluate poles and wires. So,
No, I just think, I mean, that's the whole reason the bill is in this committee, right? To make changes. That's why it's here. So I think we should just be keeping track of the changes we want to make and let the drafters know.
Agreed. I'm curious if in the House they considered a notion of having elected county assessors to oversee this, and if PBR weighed in on that. I understand that's pretty common in other states. There's some on this committee that have had loved ones that have been county assessors. But had that come up at all in the House?
Something like that. There was one version that had, so PBR currently has employees called district advisors who are expert property evaluation professionals who help municipalities right now. Currently, PBR has 6 or 7 on staff. I've heard different numbers. This one version of this had a district advisor for each RAD who would be the kind of then with the PBR director, kind of facilitating for each RAD the reappraisals and being a sort of facilitator for that. And because, you know, and those district advisors already they do facilitate a lot for towns, but it's not formally in statute like that. So I think that's the closest thing that they talked about that was similar.
I'd support making that a 4-year term elected by each county, like a sheriff or a state.
Well, these are PBR employees or not, they're, you know, they're
Let's hold off on that. We
Like,
gotta wait
report
until we
to
have
government.
actually good county government, where we have more county elected officials.
Just leave it for hot ale.
I would say an elected official versus a PBR district advisor that if you want someone who's very well qualified,
Yeah.
PBR district advisor.
Yeah,
yeah,
That's not guaranteed. And then
yeah. Absolutely.
yeah,
Touche.
okay. We,
Well, that's a pretty job.
we,
That was-
I'm just saying, I know there's.
Yeah.
I like Boston. I liked it.
Yes, that's.
I liked it. I was aware that I was making that burn, but it was good.
Went for it anyway.
I went for it either way because the district advisory PDR, they're great people. And hopefully they watch this.
All right.
Okay, so so that's the kind of the establishment for the RAVs. The next we have a transition provisions. So number one, PDR will not order any new municipal reappraisals on or after January 1, 2027. I know your interest, you had mentioned before moving up some timelines when it comes to the other ed reform stuff. I don't know if you plan to move up timelines with this or not, but this would be where you would move up timelines. The Act 68 report, though, had said that they need until 2030 to let this stuff wind down. I don't think it would be the end of the world if you tried to speed this up, but it could cause a little bit of confusion when.
No, they've been talking about going. This can be standalone. I mean, they've been talking about doing these wider reappraisals to deal with the swings in CLAs because towns can't get an appraisal, and so this one can stand on its own and just move forward. I don't think you want to change. We may change it, useless, but I don't think we're going to play with the time.
Okay, so that's the.
One quick thing. We have appraisals on the books right now past those dates, right? Because I remember when Jill came up, when Jill came in, she had a spreadsheet of how far out.
Yeah, it's all as 20, like if you cut it off at the end of 2026 and don't order new ones. The expectation is that the ones that were ordered in 2026 would be done by 2030.
Okay.
And that's basically what this is doing. So that's number one, no more orders for new reappraisals after January 1st, 2027. That means we're gonna have a gap where there's no new, like the CLAs get worse or gets better conceivably, possibly. Just apply that. Number two, reappraisal order for which municipality does not have a contract in place before January 1, 2030 shall be force of law. So if you don't get your contract going by 2030, then you're not doing it. And then third, a municipality shall not enter a new contract after January 1, 2027.
Is there a worry about contractors kind of drying up in that period since the workload's not going to be there?
I don't know enough about how these firms work. I don't think they work just within Vermont.
Yeah, most of them are not Vermont
Yeah.
only
Yeah.
firms. They're like regional or national firms, so we are just like a tiny little rounding
Or
error.
we could add a provision that if there aren't any, that they get an extension or something like that.
We'll have.
Doesn't never
Yeah.
They're one, yeah.
Yeah,
I think that the logic here, the plan is that once you've regionalized it and have a large area, that will be attractive for firms to come and do. That'd be a big contract for them.
Right.
And potentially cheaper for the state.
Right.
Economy of scale.
I say this sounds familiar to the realtors if you want to be heard on this one.
What's that?
Realtors want to be heard on this one in the future.
Yes. Thank you.
They work with a lot of appraisers. Okay,
So more transition provisions on or before every January 15 from 2027 to 2030. Tax is to submit a report relating to the progress made in preparing for the implementation of this act. I mean, I'm not sure that they'll have anything new to say in some of those years, but a lot of contact in the Department of Taxes to get ready for this. And then this is something the tax department wanted, is something from the Act 68 report. There'll be regional assessment district stakeholder working group. Department of Taxes will gather relevant stakeholders. It's no more defined than that. It's up to tax to find out who the relevant stakeholders are. And then to submit recommendations, to the legislative committees here, advising on the implementation of regional assessment districts and on the development of guidelines, procedures, and rules needed to effectuate a regionalized reappraisal system. This could be where some of that structural stuff that you were talking about before, there's feedback and they come back. And maybe they'll go into some of the things you were talking about earlier about how do you make sure the municipalities work together and stuff like that, right? And then the recommendations will include an analysis of the advantages and disadvantages of having the state take full responsibility for regionalized appraisals. And then in making its recommendation, the department shall provide suggestions for legislative language that address authority or authorities who will contract for and conduct reappraisals. So again, that could be the state, that could be some new entity. Number two, the authority or authorities who will hear and decide property valuation appeals. Remember how I said that the House at first was interested in also reforming the entire appeals process for property valuation at the same time. They let that go after testimony, and instead that's just going to be something that's looked at here. Again, the current system is the first line of appeals is grievances to your lister or assessor in town. Second, you go to the Board of Civil Authority. Third, you can go to the department. The department currently uses part-time property valuation hearing officers. They don't have a full-time hearing officer like they do for every other kind of tax appeal that happens. These are just a lot of retired folks who have knowledge of property valuation, who take on as many cases as they want, kind of thing, part-time. There was an interest at some point making a permanent hearing officer for property valuation of department. That's not in this bill anymore. But those are the sorts of things that the department could report back on. I believe that the Act 68 report did suggest having a full-time property hearing officer.
Yes, pretty sure it did.
But that's not in the bill though.
Yeah.
Another thing that we're about to get to is this bill will change the grand list date from April 1 to January 1. That will coincide with all these changes. A January 1 grand list date means that's the snapshot day for the grand list. They're like, as of this day, this is the value of the properties. Making it January 1 has advantages. This was a suggestion from the XC report. One of the there's advantages as far as the timeline. You've got more time to do certain things. One of the big things you've got more time for are appeals, valuation appeals. So, property owners could have more time. Speaking of time, am I running out of it?
No.
Okay.
You're gonna put 440.
Give them another hour.
I'm not here
There's
for
an
that.
ice cream social upstairs.
I should read. Well, you know, I'm in a better mood if you give them time to realize that it's social.
For what?
We can do that.
We should be pretty.
We've gotten through the hardest stuff.
Yeah.
So the next thing, for this report is, any other recommendation that the tax department wants to bring. I've got really good news. We've got a whole bunch of sections here that are just changing the grand list date from April 1 to January 1. Conforming changes. There used to be a lot more conforming changes in here associated with appeals and other things. And that's why we have some technical things to change in here because it's been changed a lot. But as of right now, it's just the January 1 day. Which brings us through most of the rest of this. There will probably have to be some future work from the department and from the council to make sure that we hit all of the conforming changes we need to. Just like we do with-
Yeah, and once we decide what we're doing,
Right.
yes, we need to give you time.
Fortunately, we've got these years gap here, because it's probably not just the property valuation stuff, it's also,
Oh,
Beth
I'm
and
sure.
John's stuff that's gonna have associated conforming
Yeah.
changes.
We'll be working. Miscellaneous tax.
Yes,
That's where they put the miscellaneous tax bill?
basically. No, those were my, the reader assistance.
Madam
Reader assistance had it was all me. I wrote miscellaneous text. I probably wasn't thinking about it a
Oh, I
lot.
can't decorate it.
Well, that's how it came over.
Decorate it?
Small Christmas tree.
I really miss
Small
having
Christmas
the-
This
the
is an
miscellaneous
invitation to
text.
put all of your favorite projects in the ed reform bill. Yeah, you should do that.
Okay.
So anyway. The first change here is, a provision of law that went missing at a few years ago. It was, I think this section was being amended multiple times. And what ended up in the green books was missing a sentence. It hasn't had any legal effect.
Yeah.
It's, this. For the have the department alter, the requirements under subdivision 54H2B, they have not done that. This is more of a clarifying provision in the first place, but this is a alleged council addition saying. The General Assembly did not make the conscious decision to remove this, so we should put it back.
Okay.
Uh,
Sounds like S30 today.
and this is, if you know Westlaw, an employee at Westlaw discovered this.
Oh, okay. So it is like S30. Somehow something in the green books isn't in our books. All right.
What is Westlaw?
Oh,
So it's a legal database
Yeah.
company for legal research.
You've never had West?
You never heard of Westlaw?
I feel ashamed.
It is new, it's like you pretend.
Aren't you a professor?
Westlaw?
WEST.
I think the requirements need to send it.
That's it, was one of the first.
It's on fire today.
I'm not. I
Throw
think it's
shade.
Am I? I don't want to be.
Okay, let's finish this up. This committee needs a break. I don't know if they need ice cream.
We have a
need a
We,
break.
we have a few more conforming changes,
That's conforming.
or technical changes, I would say housekeeping stuff.
All right. I think
Some of it's policy stuff, like this
Okay,
next, like
let's
this
do
next
the
one.
policy stuff because we're losing the committee.
If you remember last year, there was, I know Senator Hardy remembers this because it went through GovOps, there was the tax sales and tax abatement, bill. There was a report in there for a working group to decide any further suggestions. They did come back and reported to House Ways and Means that the group agreed that there should be a minimum of $1,500 of debt before a tax sale initiated. And, I believe it might have been the only piece of agreement from that. But
I'm not surprised.
but it's in this bill to make that suggested change.
That sounds good.
Is there a minimum now?
There's not a minimum amount, but one thing that bill did last year was to at least make sure that a year passes before a tax sale is initiated. And there was a consideration of having a minimum amount last year, but it was removed during the legislative process. And instead was studied, and then this group's agreed that.
They agreed on it, yeah.
When I was in Montpelier City government, a tax collector carried the tax records in a notebook in his pocket.
Wow. That sounds secure.
The next change is,
Secure.
We're losing everybody. Where did they go?
Emerge, big photo.
Big truck.
All right.
we're almost there.
They wouldn't let me in merge.
Yeah. Oh, and merge.
I didn't think, how you gonna?
Uh,
How do we got experience?
all right,
Okay,
I'm just happy.
next change is, from the Department of Taxes. We mentioned their part-time hearing officers for property tax appeals. Before, this relates to that. PBR had asked to change how they're paid. Currently, it's $150 a day stipend. They want to make sure they can actually recruit people for this, and they've asked to have it changed to be $38 per hour plus a cost of living adjustment. So that's what this does. Change how the part-time hearing officers are paid.
We decrease salaries in statute regularly.
No, it's uncommon to have something like this right in statute, usually that would be maybe, part of the
Just do it in
department's
your
budget or.
budget. We'll ask them.
But it was in statute previously,
They,
and so.
they figure they need to do it. We need to either remove it from statute. And tell them to do what they can during their budgetary process. So we'll have them in, because that means if we get into 15% inflation again, they're gonna have to come back, or if we get into deflation, they're gonna have to come back. So, okay,
The next changes, we mentioned this before, that $15 late fee for a late file property tax credit was intended to be removed last session, but it made its way through one spot, and so we're just cleaning that up. And then the rest of it's the effective dates. Which
Okay.
we've got the timeline that.
Yeah,
the effective date.
You still scrolling?
figured I need to cross check all those.
We pretty much laid them out for every section.
It's like, if I leave this-
And that's what's
Including the
reflected on
contingent
the
ones that I think that John mentioned to you, there's some contingent effective dates in here for certain things to happen.
Okay. And I think if all else fails, we can send this section forward. We can't agree on anything else.
And I'd like to say that you're done, but you're not, because you didn't actually hear all of Beth's sections, right?
No, we have not heard all of this, but they really are under all of our. domain.
It's mostly overhead.
We will have that back in. Maybe even as early as tomorrow, if we can. Hear back from AOE. Okay, committee, you have
4:40?
45 minutes. We'll go offline.